Goldman Sachs CEO Lloyd Blankfein may be called to testify as soon as this week in this trial of former hedge fund founder Raj Rajaratnam. Yesterday, Raj's good friend Rajiv Goel, the former Intel executive, was on the stand back here on the Inside Track with his analysis of the trial and these new developments. Is Doug Burns, former federal prosecutor. He now has his own private practice. Doug, let's start with Blankfein.
Sure.
Why? We've been asking this question ever since we heard Blankfein might take the stand. At this point in the trial, can you say, or can you explain why the government would call Lloyd Blankfein as a witness?
It's the same analysis I gave earlier, Eric, which is that, to call somebody in that lofty a position appears to try to give, big credibility to the government's case. As I said earlier, though, he's not really a substantive witness, obviously, on, specific conversations, specific insider trading. So what they do is they kind of bring him in to say that, look, we had policies against, first of all, that he served on our board of directors. Second of all, that I had advised him, as I did all board members, that, matters that are confidential are not to be disclosed. One thing about trials, just to give sort of a little technical analysis, it is building blocks. So you build every block. In other words, there was a policy. He wasn't allowed to violate it. It's sort of like just putting everything together. But obviously, when you have a name that big, we're sitting here saying, wow, this is interesting.
Well, there seem to be a couple of risks here, and let's explore the easy one first.
Sure.
The possibility that it may not matter. We know from the jury selection that the jurors have no idea who Lloyd Blankfein is. The judge hardly has an idea who Lloyd Blankfein is. He mispronounced his name.
Yeah. No, you're right. It is sort of much ado about nothing. What was interesting, though, is I read the letter that the U.S. Attorney's Office filed with the judge, and I know you're familiar with it. I heard you talking about it. And they say, look, we don't want cross-examination on whether or not, Goldman's under investigation by DOJ or the SEC, and we don't want anything about any questions asked about whether they caused or were involved with the financial meltdown of '08. Working backwards, the second question's way too broad. It's not relevant evidence. So you can kind of forget that, in my opinion. But the first one, believe it or not, I'll make an argument, which is theoretically, and I think I heard you say it, the argument is, look, if the company's under investigation, then that would shade his testimony and be relevant to his credibility. Again, a stretch, and my prediction is that the judge will not allow either areas of cross-examination, because after all, cross is limited to what's said in direct, and then we have rules that say even if evidence is probative, if it can cause confusion or delay or prejudice, it doesn't come in.
What if he doesn't grant that request? Does this then become a trial of Goldman Sachs?
That's exactly what you said earlier on the air. Then it could become really a bit of a circus. It can become way too wide open. I just don't think this particular judge is going to let that happen.
Okay, but you know the judge in this case, so you are...
I've appeared in front of him, yes.
Okay. Now, what if he does anyway? Doesn't that also run the risk of lending the trial a bit of a circus atmosphere? You know what's going to be happening outside the courtroom. I mean,
sure.
If we thought that this was a media circus already, just wait until Lloyd Blankfein walks through the front, walks up the steps of the courthouse.
No. But the point is, it's like, was your company responsible for the financial meltdown? No, it wasn't. I mean, that's the answer, right? That's a silly question, to repeat myself. Is the company under investigation by either the Department of Justice or the SEC? If the answer is yes, there are various investigations, it's sort of much ado about nothing, and you move on, no?
Okay, so let's say then that the judge does grant this request and the cross-examination is limited, the scope of his testimony is limited. What does the defense's strategy then become to discredit Lloyd Blankfein?
Well, yeah, that's a very good question. You don't really discredit him. Certain times, strategically, it's like you take the position.
You give him a pass?
No. In other words, the theory strategically being he doesn't really hurt us. Okay, in other words, he's just establishing things that we didn't even need him in here for. Okay, the man was on the board of directors. We already knew that. Okay, they have a policy against disclosing insider information. A, of course, we already know that. And B, that begs the question as to whether anybody did anything wrong. You see what I mean? And you keep your head down and you don't do much with them. Seriously.
Seriously?
Yeah.
And so, I mean, I'm still having trouble understanding what strategy then, because that's the defense, but what does the prosecution do to make the most of this opportunity? If you're going to bother calling a Wall Street chieftain to take the stand, that kind of thing doesn't happen very often unless they're testifying in their own defense.
But I don't think, honestly, again, to be a broken record, Eric, I don't think he's substantively... I don't want you to be a broken record. Yeah, I don't think he substantively tells you.
So why bother?
Anything.
Why bother?
So that you and I are sitting here talking about it?
It reminds me of what they say about dogs, right? Because they can, right? You call the witness.
Well, yeah. I mean, it adds a luster, a gloss. You know, I'm not going to specifically say, you know, they want more media attention on the case, but it's a media event. But again, I think as a lawyer, I have to break down what's his usefulness, what's his relevance. It's really not that significant. If he came in there and said, and let me emphasize that this is a hypothetical, you know, I heard A say to B, but that's not what we're talking about.
All right, let us turn to things that are substantive. Sure. The testimony yesterday of Rajiv Goel, Raj's good friend, we know that, right? They met each other at the Wharton Business School, both immigrants from Sri Lanka and India. Yes. Now, did they wait too long to bring the star witness onto the stand? This is supposed to be, from the government standpoint, right, the nail in the coffin.
That's actually pretty interesting. I didn't think about that. Here's the way I look at it. A, there is safety in numbers. So you had that first critical witness, Anil Kumar. Now you have a second really big witness. So A, you know, that is just further strength, further proof. B, it dissuades any notion that there's any misunderstanding about the first person's testimony, because here's another whole incident. I mean, a trial's like filling up a swimming pool, and you got to fill it up to the beyond a reasonable doubt line, and, you know, the water levels are rising. And I think he was a very strong witness from what I saw.
Really?
Yeah, no, he said that Intel was going to be making a $1 billion investment in a deal involving Clearview and Sprint Nextel. And again, it was very similar to the Kumar thing. The other point I wanted to work off of was your observation that they're friends. From a trial lawyer's point of view, that's important, because normally on cross-examination, if you can establish that there's an axe to grind, he doesn't like him, that can help you. Here, it's the opposite. The man's kind of shrugging his shoulders, saying, I'm friends with him. He helped me take care of my father in India by loaning me money. He helped me buy a house in California by loaning me money. And the vibration that comes across to the jury, Eric, is, hey, I was arrested. I have a family. I'm here doing what I have to do. You know, nothing personal. He's my friend. That's worse for the defense.
All right. Doug, we're going to have you back for more play-by-play, post-game analysis of the Raj Rajaratnam trial. Thanks so much for joining us. Doug Burns, a former federal prosecutor, now in his own private practice. We're talking about that phenomenal case and the pending appearance of Lloyd Blankfein, the Goldman Sachs CEO.